So good morning, and thank you so much for joining today's CPA webinar series, IRS Appeals Update. Before we get started, I just want to touch on a few housekeeping items. Today's webinar is being recorded and will be posted to our website following today's presentation. For any of you all seeking CLE or CPE credit, we'll be posting information in the chat feature during the halfway mark of our presentation. For those of you licensed in New York, or listening via phone, we will read aloud the affirmation code. And lastly, should you have any questions during the presentation, please be sure to put them in the chat feature and the presenters will be answering them as they come in. Now, I'd like to take a minute to introduce our first speaker, Mary McNulty. Mary is a tax partner in Holland & Knight's Dallas office and the co-chair of its tax controversy team. She represents large business taxpayers in Internal Revenue Service audits, appeals and tax litigation with emphasis on federal tax procedural issue, interest, penalties, and partnership audits. She's a frequent speaker and writer on IRS audits, appeals, and tax litigation. And without further ado, I'll let you take it from here, Mary.
Okay, thank you, Paige. And thank you everyone for joining us today. I'm going to introduce our other panelists and then we'll get started. So Abbey Garber. Abbey, raise your hand. Abbey is my partner in the Dallas office. Before joining us, Abbey served for more than 30 years in the IRS Office of Chief Counsel. He oversaw all small business self-employed, also known as SBSE cases in Texas and Louisiana. And Abbey now handles IRS tax controversy and collection issues for a wide range of clients, including individuals and small and mid-sized businesses. Next is Jim Dawson. Jim, raise your hand. Jim is a partner in our West Palm Beach office. Before joining us, Jim was a trial attorney for the IRS Office of Chief Counsel. He tried many cases before the United States Tax Court. He was also a CPA at a Big Six accounting firm. And Jim now handles IRS tax controversy issues for corporations and high net worth individuals. And lastly, we have Amish Shah. Amish joined us recently and we're really excited about that. He is our partner in the Washington, D.C. office. Amish has extensive experience handling tax controversy matters for clients in the energy sector. Before becoming a lawyer, Amish practiced as a CPA at a Big Six accounting firm. So I'm going to turn it over to Amish now to get us started.
Great, thanks, Mary. Before we get into talking more about the appeals process in some detail, one of the questions that comes up from clients is, as we're dealing with controversy matters, is, the role of their CPAs and the role of their attorneys. And this came up back when I was a CPA, and it's come up as I've been an attorney as well in this. And one of the things to think about as we're going through the various steps in the appeals process is, at a high level, our clients benefit from having a team that includes both their CPAs and their attorneys. And what we often do is again, this depends on the issues that are at appeals, but it's often helpful to have the CPAs that were involved in the exam continue to be front-facing during appeals as well, with the attorneys often in the background to help evaluate hazards of litigation, take a look at the courts that are available to the clients, take a look at the cases that are decided in those courts, and otherwise to provide legal support to the clients. And then oftentimes, as we'll talk about as we go through the appeals process, IRS counsel will get involved, national office will get involved, and appeals will bring in its attorneys. And so that's often the time where we advise clients to then have the attorneys perhaps take a more active front-facing role, with the CPAs continuing to be very involved in the case, since obviously they've got the history with the case and they have the deep knowledge of the facts. So, that's just a sense of kind of the various roles of the team. And I think we'll now jump into the actual appeals process, and I'll send it back to Mary.
Okay, thanks, Amish. So this slide tells you the mission of appeals, and importantly, appeals, their purpose is to resolve tax cases without litigation, and they, on a basis that's fair and impartial to both the government and the taxpayer. And they really want to enhance public confidence in the service. And so what's critical is that appeals be viewed as independent by taxpayers. Otherwise, their mission is going to fail. So appeals takes into account hazards of litigation while analyzing cases. And, they take into account hazards on both sides for taxpayers and for the government, for the IRS. And, their job is to assess the hazards in a fair and impartial manner, and then to resolve the case, make a settlement offer and resolve the case with the taxpayer by settlement. The exam team does not need to agree on the settlement. It's between the appeals officer and the taxpayer. So appeals, their mission was codified in 2019 in the Taxpayer First Act. So you can find it there. So moving on to the next slide, we wanted to set the stage about the next slide, please. We wanted to set the stage about what appeals does. So this slide provides a brief background on the types of cases in terms of the taxpayers, the types of issues, and from which exam function the case comes from. So you can see on the left the various work streams, but the two biggest sources of cases for IRS appeals, first would be collection due process cases. And in 2020, that was about 25,000 cases. And then the second biggest category of cases are cases coming from the examination team, and that's about almost 20,000 cases. This slide was based on numbers from the IRS fiscal year ending in September 30th, 2020. And at that time, the numbers went down significantly because of the pandemic. So at that point, there were 57,500 cases versus before the pandemic when there were about close to 85,000 cases. So the cases are back on the rise as IRS enforcement has increased, although it's not yet back to pre-pandemic levels. In 2021, IRS appeals closed about 65,000 cases, and in 2022 closed about 75,000 cases. So they're getting close to the 85,000 pre-pandemic cases, but not quite there yet. But staffing has mirrored IRS enforcement. So the numbers, just to give you some perspective, in 2012, there were 2,100 appeals officers. In 2018, that dropped significantly. There were only 1,200, so almost dropped by half. It's been steadily rising since then as IRS funding has increased. In 2022, staffing got to about 1,500. And in 2023, the IRS appeals has been authorized to increase staffing to 1,750. So IRS appeals have been hiring. They're making good hires from people who really gone outside of the internal IRS network and are also hiring now externally and getting some really good practitioners who have a lot of experience with IRS appeals. So the next slide. So if your client's been audited, they want to dispute the proposed adjustments that exam has made. The first question you need to ask is, can they go to IRS appeals? And generally, the appeals process is generally available to all taxpayers. And that was codified again in 2019 in the Taxpayer First Act. But courts have held that this right is not absolute. Appeals process is generally available. That doesn't mean it's always available. So there have been recent court cases that have rejected taxpayers' attempts to get to appeals when they were otherwise denied. Proposed regulations were issued recently that set forth some exceptions when you cannot get to appeals. Some of them are controversial. for example, procedural challenges to IRS regulations, notices, and revenue procedures, also known as APA issues. That those aren't appropriate for IRS appeals. But others, if the statute of limitations is running, sometimes appeals will have to issue a notice of deficiency without considering the case completely. And in those cases, even though normally you only have one shot at appeals, if you went to appeals but didn't get to finish because the statute was expiring, at that point, appeals will issue the notice of deficiency, and then the taxpayer can choose to file suit in the tax court. And at that point, we have what's called a docketed appeal. And Jim Dawson, I'm going to turn it over to you to talk about docketed appeals.
Mary, I mean, one thing on that, just a question on that is, before, we talked about the right to go to appeals. And so we sometimes have clients ask whether they should go to appeals and take the time to go through that process. My view, and obviously be happy to hear other people's views on it, is in most cases, I do advise clients to take a shot at appeals because we have had good success over the years in resolving cases in appeals short of litigation. And so we, limited downside, certainly there's some costs associated with going to appeals, but if you can settle a case in appeals and not have to litigate, there's a large cost savings for our clients as well. And so in most cases where we think there at least is a legitimate shot of resolving a case at appeals, we do, advise if the opportunity is available to go down that path. But I don't know if anyone is, advised otherwise or seen situations where, maybe it wouldn't make sense to go to appeals.
Yeah, I had a situation where the issue was a coordinated issue, the self-employment tax issue for limited partners. And in that case, we went to appeals, but then a national office kind of swooped in and took the case away from our appeals officer and required a total concession. So then for the next cycle for that taxpayer, we went to appeals again. And we didn't have a conference in that situation because, again, the appeals required a complete settlement. So if settlement doesn't look like it's, possible, then you might not want to go to appeals. But if you want to, depending on the type of taxpayer, in some situations, taxpayers can recover attorney's costs. And in that situation, you need to have exhausted your administrative remedies. And so you would want to go to appeals in that case, even if there's really no chance of settlement. So Jim Dawson, it looked like you might have had an experience you wanted to share.
Well, I was going to say, this is the beauty about what you just talked about in terms of docketed appeals, which is the next slide. And it addresses one of the concerns that Amish has raised is, when do you go to appeal and when do you want to basically go forward on litigation, but at the same time still have an opportunity to meet with appeals? And you have to remember there's a large group out there called Office of Chief Counsel that will be invited to the party when you have a docketed appeals case. And so there is guidance, informal guidance, that deals with this subject matter, and that's Rep. Proc 2016-22. So once a case is in appeals, one question comes up, because you've already been dealing with exam, is can exam have independent communications with appeals? And the answer is no. But can communications between counsel and appeals occur? The answer is yes. And the reason is why? Well, because the ex parte rules don't work for docketed cases, because the lawyer representing the IRS at appeals is the lawyer working the case in terms of the Office of Chief Counsel. That is, whether counsel participates or not, IRS counsel will continue with trial preparation, which may include, but is not limited to, asking what's called informal discovery conferences while the case is pending in appeals. So you have you have to deal now with appeals and you have to deal with IRS counsel at times. Now, counsel will refer a docketed case to appeals within 30 days of the case becoming at issue. In other words, when the government issues its answer, most times there's the issue of replies and so forth. They may delay forwarding the case to appeals. For example, they think that they can file a motion that will dismiss the case, a motion for summary judgment. In that case, they will retain jurisdiction, or if in the petition, the taxpayers counsel or the taxpayers raise a new issue and they want to do a little bit more discovery. So then the question is, okay, so who's got jurisdiction over this case? When a docketed case is forwarded to appeals for consideration, appeals has the sole authority to resolve a docketed case through settlement until the case is returned to counsel. So what is the difference between a docketed appeals and a traditional appeals? Well, some of the questions are, will the taxpayer be allowed to submit a protest? May exam get involved if the taxpayer did not cooperate during the audit? Abbey and I just recently had a case in which we did not have the ability to go to appeals prior to the issuance of the stat notice. The case went to appeals, and at that time, the appeals officer requested something that at first was, caught me off guard. They wanted to have exam and counsel have a pre-conference. Being a litigator, as Abbey and I are, we were a little puzzled at first. Why is this occurring? Counsel should be preparing for their case like they normally do. An exam really shouldn't be involved in an appeals matter. What I found fascinating and very helpful was the pretrial conference was one of full disclosure. It helped us understand better the IRS position. So they spoke for about 2 to 3 hours. And after that meeting, we had a better understanding of the IRS position. So in hindsight, it was very welcoming to hear from them. Would you agree, Abbey, on that, on how that case proceeded? Abbey?
Yeah, if I could unmute myself, I could agree. Yes. Yeah, the advantage to us was just taking a couple of hours listening to exam, appeals, and counsel lay out their case for us. And then when we went to our appeals conference, we were able to respond effectively to the concerns they had raised. But like Jim, I was a little bit taken aback by how much participation counsel had in this pre-conference. My expectation was exam was going to come make their case. But they had worked with counsel quite a bit before the stat notice came out. And when they got to certain issues, counsel took the lead on that. And Jim, before we go back to you, had a couple of questions in the Q&A, and I'm going to take one, and then I'm going to let the panelists take the other one. The first was, where does going to the taxpayer advocate fit in? And the question is prior to appeals, and the advocate is supposed to be there when the system just isn't working. So typically, you're in exam or collection before going to appeals, and then your next thing is to file your appeal and get to appeals. I wouldn't see a role for the advocate there. But if for some reason you have filed your protest with exam, and yet appeal says they never got it, exam isn't returning your calls, then I think that'd be an example of a perfect time to go to the taxpayer advocate, because there's a monkey wrench in the system somewhere, and we need to figure out where it is. The advocate doesn't want to substitute their view substantively. They want to make sure the case gets back on track. The next question, and Mary, I'm going to call on you first. Do you happen to know whether any substantive comments were made to the NPRN for access to IRS appeals? And are attendee says completely agreed on the controversial limitations in those proposed regulations, and that might create a foundation for an APA challenge to final regulations there. So this could probably be a whole nother webinar, but Mary, do you want to touch on that briefly?
Yeah, Jim Dawson's our APA expert, but I do know that comments were submitted in response to the proposed regulations, and that this procedure or that this exception to access to IRS appeals was one of the most commented on provisions, one of the most controversial. Yeah, I mean, people think appeals should still apply the guidance to the taxpayers' facts and circumstances without regard to whether there's an APA challenge at issue. Jim, you have anything to add?
Yeah, I mean, you hit it right on the head, Mary. The APA will be at issue. What I found to be very concerning in looking at the comments and the proposed regulations is how the regulations were broadened to basically allow appeals to basically not have to have the case presented before appeals. So what do I mean by that? We've all heard about this designation of litigation standard, where the IRS, throughout the process of exam, basically gets to bypass a 30-day letter and issue a stat notice, and IRS counsel proceeds with the case. But there's also the standard for the sound administration concept, which is out there like a lion waiting for the ambush and you're the prey. It seems that the IRS, and they keep talking about historical practice, the historical practice has been always for designation of litigation to be, there was a process, and Abbey can talk about it a little bit more. There is a process for how you designate, and it's very rarely used. The sound administration, however, lies there in waiting for IRS counsel if they deem it necessary to basically retain jurisdiction of the case. There is no judicial right for you to try to get the case down in appeals. Now, the issues that they delineated about, that the regulations didn't conform with APA, that it was already the process of TAM, those will be subject to an APA challenge. I'm convinced of that. Abbey or Amish, do you have any thoughts?
I think you all done a good job covering it.
And Amish, real quick, I just dropped in the CLE and CPE information in the chat feature, but for those of you that are listening via phone call and need an affirmation code, that is HK2301204368. And again, that is in the chat feature for everyone on the call. Thank you.
So why don't we go to the next slide? I being an old guy, I tend to yap a lot, so I want to give time to my my fellow colleagues. So why don't we go quickly to the next slide, which is slide 7. Perfect. And so what this basically is something to always consider is appeals needs time to consider the case, right? So there's what's called statute of limitations for the IRS to get a hold of the case at appeals and be able to try to settle the amount. And this slide lays out the time periods that must be left on the statute of limitations for assessments for appeals to accept the case. So really, the easiest way for me to look at this, or for the audience to look at it, is the distinction between partnership cases and non-partnership cases, specifically as the partnership, TEFRA and non-TEFRA and BBA. So let me first go through non-TEFRA, which is anything other than partnerships. Appeals requires at least 12 months. Exam may add additional time, i.e. they need to process some of the paperwork, close out their case. So they'll ask the taxpayer, we need an extension of time in order for me to get this case in a timely fashion to appeals. In the TEFRA proceedings, appeals requires at least 12 months. And again, exam will add on another 8 months. BBA cases, which is something that, we're all dealing with, it's rather new. That's a different creature. So per the Internal Revenue Manual, there must be 365 days left on the statute in order for appeals, IRS appeals to accept the case from exam. Per the IRS website, however, it's 18 months. So we got to figure out which one they want, a year or 18 months. However, there's a little unique quirk with the BBA, and that is you get 2 bites of the apple in appeals. One is to the substantive issues that you get to dispute. And so the IRS wants 120 days left on the statute when issuing the notice of preliminary partnership exam changes. And so you at that time can basically go into exam, go into appeals and contest the substantive matters. Now, the appeals looks at it in terms of they have to issue the NOPA within 3 years after the latter of the date when the partnership return is due or filed, or an AAR is filed. However, you get the second bite of going to appeals. So after the NOPA is issued, there's this issue about modification requests. We don't have much guidance with the appeals process for modification requests in terms of what will it look like, including how much time a partnership representative will need to have left on the statute to go to IRS appeals for the second time. It's not stated in the IRM and it's not in the IRS website. However, it's important to remember that any adjustment must be made within 270 days plus any agreed time in the extension after modification information is submitted. So it'll be interesting to see how this statute of limitation issues in terms of how much time is left on the statute proceeds. You got to remember one thing though, is IRS appeals does not like granting multiple extensions. Appeals may require the case to be closed after you reach a resolution, a closing agreement, or an 870 AD within a certain period of time from the extended statute date. And the proposed regulations elevate, which is also potentially an APA issue, IRM guidance into the regulatory rules. With that stated, I will go on to the next slide and I will turn it over to Amish.
Great, thanks, Jim. So a question that often gets asked is, okay, we've decided to go to appeals. How long is that process going to take before we resolve the issue at appeals if it is going to get resolved at appeals? And so when we think about the process, right, we get the 30-day letter, we file a protest. Oftentimes exam will file the rebuttal and that package goes to appeals. And it goes to a processing group, and that processing group, according to Taxpayer Advocate in their 2022 statistics, they get about 74,000 cases that go to them, and there are about 200 people in that group who process those cases. And so they ultimately then assign the cases to an appeals officer. And you'll get a letter letting you know to whom it's assigned, and the appeals officer should reach out to set up a conference. And so, as far as kind of timing for, from the case going to appeals to the time in which the appeals officer first reaches out, that can take, several months. You may look at that taking 3 to 4 months. As Mary talked about, staffing at IRS appeals among appeals officers gone up and down. It was significantly lower for some period of time, even though the caseload wasn't lower. And so you have appeals officers who can be quite overloaded. And so the time before they can actually reach out to you can take a little bit longer. But once they reach out, again, the case should be set up for a first meeting within 2 to 3 months after that. And
hey, Amish, could I jump in for just a minute? Because I wanted to mention that first letter that you get from the appeals officer has been changed. It's called a contact letter, and it will include both the name of the IRS appeals officer to whom the case is assigned. But more importantly, the new part of this is that it will include that person's manager. And the reason for doing that is if there ends up being a problem along the way while you're in appeals and you want to elevate and talk to the manager, you won't be in this awkward position of asking the appeals officer who your manager is, because the IRS is now being upfront and telling you. And I think this is unusual. I don't know about you, Amish, but I haven't had too many times that I've been in IRS appeals where I've elevated. But it's still good to know who that person would be, and it takes away some of the awkwardness of elevating.
Yeah, no, and that's a great point, Mary, because we have had situations where we've had to elevate for non-responsiveness from an appeals officer. Unfortunately, in some of the situations we've had non-responsiveness from the manager as well, but it's good to have the information and to be able to have additional avenues to move the case forward, because this is something that can take some time, and where it gets stalled or where there are issues, including issues of fairness, it's good to have additional avenues to be able to try and resolve the case with the manager. So then once you have your first meeting, then it can be a little bit all over the board in terms of how long it takes to get from first meeting to resolution of the case. Statistically, the average has gone up. In 2018. It was 194 days, and in 2022, it had gone up to a full 360 days. But a lot of it can depend on how many issues are at play, how many appeals officers or experts or others are getting involved in the IRS, how many meetings are required, whether the case has to go back down to exam for additional factual development. We've had one case that it was 2 hours, or maybe it was an hour actually, from the beginning of the first appeals meeting until resolution. We had a pre-conference where exam spoke. After exam spoke, appeals fully conceded before we even presented our case.
Wow, that's a great result. Very unusual, but it's a great result. Hours, right?
Very unusual, but and on the other hand, we've had situations where there have been 4 or 5 appeals officers on a case, and IRS has brought in outside experts, and they've had internal industry experts, and we had a number of meetings, and the appeals process lasted several years before we got to resolution. And so, it can widely vary depending on the complexity of the issues, the number of issues, among other things. But again, you'd hope that you'd be closer to the average of resolving this a matter in less than a year at appeals. So in terms of ability to there is a website. It's on here to check the status of your appeals request. But again, I think as compared to litigation, this can often be a much quicker process. And again, if you have a single issue that's relatively less complex, it can be a faster resolution as well. Anyone have anything else on that? Otherwise, I'll turn back to Abbey.
Okay, so as you see, our slide is conference expectations, and we started talking about that a little bit. But during COVID, naturally, there were no in-person meetings, and so at that point, cases are not being assigned based on geography. And actually, appeals started doing this before COVID, but the pandemic really escalated it. It helps appeals manage their workload. If they could move cases around the country, they could take advantage of expertise in different parts of the country, and this continues. Now, during the pandemic, appeals is not going to say, we'll just postpone everything until you could have an in-person conference. They said, we're going to do it virtually, and that's how they're handling their conferences. They now have resumed granting in-person meetings. They are required to grant them on request, but we've noticed that they're reluctant to do so. You've got some cost concerns, you've got some COVID concerns, you have some travel concerns, and frankly, I think the appeals officers are very happy working remotely. They're used to handling conferences that way. So when you ask for an in-person meeting, most of them, their initial reaction is, well, why do you think we need that? But I like in-person meetings personally. Now, I think you need to look at every case and figure out, does it make sense, especially if the appeals officer is in a different location and you're gonna have a lot of people traveling, then maybe Zoom would help. But again, I just think there's times when you could be more persuasive in person. You could read the people in the room. Again, if there are going to be a lot of people in the room, you could try to ascertain who are the real decision makers here. And so I think there's a lot of reasons why you might want to have an in-person conference. And Mary, did you want to jump in on that?
I did, because I recently had a appeals conference by Zoom, and it worked really, really well. So I was always under the, kind of best practice has always been request a face-to-face conference for all the reasons that Abbey explained. But I think with the technology and the way it's moved and more people getting comfortable on Zoom, that Zoom does work. You just need to make sure you have ground rules set with the appeals officer, make sure everyone's on camera, and but I definitely prefer Zoom over a telephone appeals conference, because you can read the room, especially if it's only one appeals officer and that's it. By telephone, I find it to be much more difficult.
Yeah,
Right.
One of the challenges even pre-COVID was, we'd be granted in-person conferences, none with you. I mean, that was by far preferable to the telephonic conferences pre-COVID. But even then, where you had a complex case that had several people involved, you'd show up for the in-person conference and then someone couldn't make it, and they were then on the telephone. And so, and obviously it was hard to tell how much they were paying attention and how involved and engaged they were in that. And so I do go back and forth now in terms of in-person versus video, whether, if I'm going to be in person with a decision maker, but there are other people who are going to have kind of an important role in the decision that I can't see at all, and they're going to be on the telephone, versus a Zoom meeting where again, if you set the ground rules, as Mary said, of having everyone on video, I can at least see everyone. My preference obviously would be have everyone in person in a room, but the IRS doesn't always cede to my preferences there.
One comment is the following. It's the reason I like in-person meetings is I have greater ability to control the message. What do we mean by that? Right now, we're all on Zoom. Some of the 52 participants right now may be watching this, or it may be they went outside to get some coffee. So I don't know who's watching my presentation. Simple as that. Second, if I am very prepared for the case, I want to be looking at the appeals officer and be able to make sure that that appeals officer is listening to what I am saying. Zoom, which is great when you're in multi-office or multi-locations, doesn't allow me to be as persuasive as if I were in that room looking at the person one-on-one. And with that, I'll be quiet and I'll turn it right back to Abbey.
Jim, I can't believe you think somebody would step out for coffee during my part of the
No,
presentation.
they did it with mine. Don't worry about that, Abbey. Not yours, just mine.
Right. So, and Mary and Amish make a good point about an expectations call in advance. If you're going to be using a Zoom for the appeals conference, have that expectations call in advance to set the ground rules, introducing participants. We want everybody to have their camera on. We want to make sure that we can share our screen. If we're going to put documents up, we want them to be able to share their screen if they're relying on something. Test the technology in advance and not just the day of the conference. And appeals has guidance out there on that they're supposed to abide by these best practices, and so we like to encourage them to do that. And that none of this makes a difference whether it's a docketed case or a non-docketed case. Again, it's your chance to get with appeals, and you should have their full attention regardless of the technology used or in person. So we wanted to cover that. I think Mary mentioned how the contact letter has been revised. And again, supposed to give you the name of the manager and their phone number. And again, there's always tension. And I don't know if anybody wants to weigh in on this. I don't want to, if the appeals officer doesn't return my first phone call within 5 minutes, I'm not going to run to the manager. But if I tried the appeals officer a week ago, and then I tried the appeals officer yesterday and again today, then maybe I do call the manager, and maybe the first call isn't your employee is completely non-responsive and I need a new appeals officer. Maybe it's, I was trying to reach the appeals officer, I didn't get a call back. Are they out on leave or working on another project? And if so, when do you expect them back in? Something like that. Does anybody have a better way of gently approaching the manager, at least the first time?
Yeah, your approach is spot on, Abbey. I mean, and sometimes I'll even leave on the voicemail or the email for the appeals officer to, let them know that I hadn't heard from them, and we may just check in with their manager to see if everything's all right, so that we're not stepping over the appeals officer without at least giving them a heads up, and maybe even an opportunity to then respond after hearing that voicemail.
That's a great idea. Mary?
Yeah, Abbey, the contact letter also now includes some information about secure electronic messaging. So basically secure email. And so I found that, that does get the appeals officer's attention because they like this new system. So if you fill out the paperwork and send it in, I found that I get an email invitation pretty quickly from the appeals officer.
Yeah, and that secure messaging system it is user friendly. Some people are surprised when I say anything about the IRS is user friendly, but we have used that. I still, if an appeals officer or any IRS employee is willing to share their email with me, that's my preference. I much prefer that to any of the other possibilities, but the secure messaging does work well.
Well, right, but just one point on that, Abbey. I mean, a taxpayer and the representative can always choose to transmit confidential taxpayer information by email, but the appeals officer, the IRS, cannot do the same in return. So, yeah, you want their email address maybe for things like, hey, can you call me next week or whatever, but you're not going to get anything substantive back from the appeals officer unless you have secure email.
Right, but just for quick logistical things, some of them are willing, right, to say, yeah, Tuesday at 9 o'clock is fine, or something like that. And you don't have to put the taxpayers. You hope they remember which case they have with you, but I can always just in the subject line put R asterisk asterisk asterisk, and that at least narrows it down to which letter of the alphabet the taxpayer's name begins with, and they'll say, oh yeah, you're working on the such and such case with me, and yes, I'll call you Tuesday at 9 or something like that. One thing, it's not on the slide, I was going to mention briefly, is that there's a federal rule of evidence 408 that says settlement discussions are not admissible in court, and all discussions with appeals, frankly, are settlement discussions. So if you filed a protest of what exam is done, and or you have a docketed case and counsel has referred you, as they're supposed to do 99% of the time, to appeals to resolve the case, then what you say to the appeals officer should be considered privileged, and you can have a frank discussion where both parties could talk about hazards of litigation, which appeals is supposed to consider. And one advantage of dealing with appeals over exam is they are allowed to take the hazards into account without fear of my comments are going to be held against my client if we do have to go to court. Does anybody want to jump in on privilege before we go to the next slide?
Yeah, I mean, just on that federal rule of 4A, just a point of clarification. The conversations themselves are privileged. However, that does not mean that you can waive your client's privilege. And I'd like to hear from Abbey, Mary, and Amish on that. You have to remember you have the attorney-client privilege, you have the 75-25 privilege, and you also have something called the work product doctrine. So the fact that you're in appeals, you don't want to do the foot fault of waiving those privileges, thinking under Rule 408 that some way, somehow, these conversations that you've had are somehow privileged. You have to be very careful when you have information that by itself is independently privileged, and how you go about using that. For example, when you're trying to get a negligence or, God forbid, a fraud penalty or penalty being asserted, and when you have material that's privileged, and how you go about trying to present that before the appeals officer. I know Mary and Abbey and Amish have been writing extensively on what is pending before the Supreme Court in the grand jury, and I'd like to hear your thoughts on the privilege aspect of Rule 408 too.
For the case that Jim referred to in grand jury, the Supreme Court heard oral arguments a couple of weeks ago, but the case involved what's called a dual purpose communication, where some part of the advice was tax return preparation, which would not be privileged, and the rest of the advice is privileged communication, involves a legal issue. So the court's grappling with, what do you do in that situation? Is the entire document privileged? Is it possible to redact? If so, redact and produce the rest of the communication. But what they're really, the test that they're grappling with is, does the communication need to have a significant purpose, significant legal purpose, or does it significant or primary purpose? So the taxpayer is arguing that the primary purpose test would require courts to look at all the purposes and pick out the most important purpose. And if that is tax return preparation, then the entire document is not privileged. And then that's the government's argument. And then the taxpayer wants a predominant purpose test, which they've now viewed as a kind of any legitimate purpose. So yes, there's tax return preparation, but there's also this other purpose of some legal communication. And so the entire document should be privileged. So it'll be interesting to see where the court comes out. I've gotten out of the prediction business lately, but so I'm not going to comment on that. Amish, do you have anything to add?
No, I think that covers it well. And
Okay.
I also won't predict on this one.
Yeah, so instead of predictions, we did a hard-hitting client alert that you could find on the internet, where we took 10 quotations from the lawyers arguing the case and the justices hearing the case out of context, and just gave you our top 10 list of what we thought were funny quotations from the oral argument that there was a week or two ago. So let's go to a role of specialists and or counsel, which we've already touched on a little bit, but Amish, I think you've got some more to say on that, please.
Yeah, so we alluded to before, having in-person conferences, and one of the reasons for that is to make sure we know who the decision makers are for the case. And so one of the reasons that becomes of interest is because the appeals officers are permitted to bring in chief counsel attorneys, and this is under the Taxpayer First Act, codified their ability to bring in and obtain legal counsel from chief counsel attorneys. And so those attorneys are required to be, or supposed to be, folks who are not advising the exam on the case, and who aren't advising or preparing the case for litigation. So you first may have attorneys involved in your appeals matter. The second is the appeals officer may decide to bring in a specialist. And we see that often in cases that are in more kind of less traveled, I should say, areas. We see it in some excise tax issues, some tax credit sorts of things that aren't the things that appeals officers are used to dealing with on a day-to-day basis, and often other sorts of complex, general complex tax issues that the appeals officer isn't as familiar with. And so they'll bring in a specialist, generally internal specialists. We've seen on occasion where they get authority to bring in outside specialists as well. So you may have a team of folks that you're dealing with when you're at appeals. Now, ultimately, the decision maker is your appeals officer. The appeals team case leader is the ultimate decision maker. And they may also have other appeals officers that are working with them as well. Again, we've had complex cases where we have, 4 or 5 appeals officers, and there's the appeals team case leader, the ATCL, who is the one that ultimately makes the decision on the settlement offers back and forth. One of the things to be, and they have the authority to do that generally, other than in certain coordinated or emerging issue cases. So that's generally your decision maker. One of the things to be thinking about, when you're in the room or on the Zoom is to get a sense of how much of that authority is the appeals officer really taking themselves, and how much are they deferring to the industry specialists or the attorneys. And oftentimes you'll see, especially in a case where, in an issue that a specialist or counsel may be very well versed in, but the appeals officer is less versed in, you may see a little bit more deference. And again, as you're doing your appeals conference, whether it's in person or Zoom, and hopefully not by telephone, you start to get the sense of the roles that these folks are all playing in your appeals conference, and who is really driving a lot of the decision making in the process.
Yeah, this is where it really helps to have a strong appeals officer who will listen to the specialist and to counsel, but will still independently assess the hazards of litigation and make their own decision. And this area, if you don't have an appeals officer who is doing that, this is where it has the biggest impact on taxpayers' perception of the independence of IRS appeals.
So why don't we go to the next slide? So we've touched on, we can go to slide 11. We've touched on, your ATCL is the one with settlement authority, and that is a person that's in the room with you, virtual or actual room with you, who's listening to the case, who is the one who is evaluating the discussions. There was a time in 2017 where they had to go get the ATCL had to get manager approval to approve any settlement, and there's quite an uproar around that, because as practitioners, when we are representing our clients at appeals, and we're spending hours upon hours and sometimes weeks and years with appeals with our appeals officer, we want them to be decision maker. We want to know that they've got the authority to make the final decision on this, because they're the ones in the room and they're the ones that are hearing this. And so the concern, was over all of that being subject to review by a manager who hasn't been in the room, who hasn't been listening to all of the discussion and all of the discussion on the various legal points and factual points that have been raised. And so IRS says,
Amish, ATCL, those are the appeals officer in the really large cases. So the procedure you're describing now is for those large cases, but in smaller cases without ATCLs, I'm finding that my appeals officer does need to get their manager's approval. And it's been, that hasn't been an issue, but it is still exactly what you're describing, which the manager has not been in the meetings with the taxpayer with you. And yet they do have the ultimate decision-making authority. So I just wanted to note that, because there is still that difference.
Yeah, no, that's a great point. All right. I don't know, in the interest of time, why don't we go ahead and move to slide 12, unless anyone else has anything here. I know we're running up against the bottom of the hour here. Abbey, do you want to take 12?
You bet. Thanks, Amish. And we do have a question in the Q&A. How do you approach appeals for penalty abatement on failure to file or late filing? Forms 3520, 5471, 5472, 8621, which is PFIC, 8992, which is guilty. I don't think I want to tackle that one standing on one foot with just a couple minutes to go, but I guess number one is depending on whether or not the penalties have already been paid, you can put in an 843 claim for abatement. Anybody want to jump in real quick on that before I talk about requests for a case file, or if not, we can get with the attendee later. All right. So I'll tell you what, happy to talk about this offline, as they say. So our last substantive slide is request for a case file, which lays out 3 ways for taxpayers to obtain the IRS case file. You want to know what's in there, obviously, but you also want to know what is not in there. Remember, the role of appeals is not to develop the case, and the appeals officers don't want to develop the case. A lot of them spent half of their career as revenue agents or revenue officers or otherwise, and now they see their role as the independent office of appeals, and they're the judge, and they're going to evaluate the case based on what is in the file from IRS and from us representing the taxpayers. So here, if the IRS doesn't document something crucial to their case, we're going to, and we know it's not in the file because we've asked for the file, either asking appeals through Taxpayer First or through FOIA, or just, I like to just, my first conference with the appeals officer, I like to say, hey, just, can I get a copy of your file and not have to go through all this formal procedures? And some say yes, and some say no. A lot of them, the answer is kind of halfway in between, but we have their file. There's something that's not in there that the IRS would need to prove their case. We're going to ask the appeals officer to make the negative inference. That document must not exist, or the IRS would have included it, and the IRS hasn't proved their case, and we should get a favorable resolution. So again, if they're representing a smaller taxpayer, as you see on the slide, it's a little bit easier to get the file before the appeals conference. Everybody has a right to do a FOIA, Freedom of Information Act request for your file. The law is that they should give it to you very quickly. Instead, you will get a letter, usually quickly, saying they need more time. But they are getting, the IRS is staffing up. They're getting a little bit faster about responding to requests. But again, look at what they've given you. If it would make sense for something to be in there that's not, then you need to decide, am I going to keep asking, or am I going to tell appeals, here's the whole file from FOIA. The IRS hasn't made their case. You need to give up, or you need to give up X% of the case. Okay. Hitting the bottom of the hour here. I hope everybody saw the link in the chat for you to get your CLE credit or CPE credit, or whatever else you need. I'm going to go back to the affirmation code for those of you in New York. And I think we're actually rooting for the New York Giants this weekend. Mary, is that right?
We are.
Not if you're married to somebody from Philadelphia.
Oh, okay. All right. Yeah, I forgot about that part of the deal. But Cowboy fans, may if nothing else, to us to get a home game after we beat San Francisco, of course. And I'm planning on our kicker being the star player in that. Anyway, New York affirmation code HK2301204368. Again, thank you all very much for attending. Call any of us if we can help you or your clients with anything we've talked about today, or anything else, frankly. And great job to my co-panelists. Always enjoy presenting with you.
Great. Thank you.
Thanks, Abbey. Thanks, everyone.
Thank you.